Good morning. Welcome to our program. This is Kelly Trudell. I'm standing in for Jim Reedy, who has caught another call right now, but we are going to get our program started this morning. I'd like to introduce attorney Karen Whitley, who is a shareholder in our Boston office in the Labor and Employment Group. Today, she's got a great program planned for you. The topic is compliance update, state paid family leave laws in Mass and New Hampshire. I'd like to introduce Karen. She will be accepting questions at the end of the program. And you also will see at the end of the program, we also note all of the information about credits. With that, I'd like to introduce Karen.
Good morning, everybody. And I expect Jim may sign on at the end and give a little bit more detail, as he always does, about upcoming programs that you'll want to pay attention to. So without further ado, I am going to be speaking this morning about state paid family leave laws in Massachusetts and New Hampshire. But as you'll see, I'm also going to give some updates about some other types of paid leaves on the federal level that you have probably heard about and want to know a little bit more about. So we'll talk this morning about the New Hampshire paid leave program, Massachusetts Earned Sick Time, Massachusetts PFML, the Massachusetts COVID Sick Leave Program, and then two federal guidances that do require employers to give some paid time off. But as you may know, the last on this bullet, the large employer ETS put out by OSHA has been stayed currently. So the first and the last bullets on this agenda are the ones where there's a little bit more uncertainty, but I will give you at least the highlights so you know what to be looking for and listening for. So let's talk about the New Hampshire paid leave program. So this is called the Granite State Paid Family Leave Plan. It was signed into law June 28th, I believe, of 2021. And it is basically the state of New Hampshire subsidizing a paid family medical leave insurance policy, and it will let employers of certain sizes join in. So over the next 18 months, we'll be hearing more details about what this is going to entail in terms of funding and logistics. But currently what we know is that there are approximately 10,000 New Hampshire state employees, and they will be automatically enrolled at no cost. So they will receive this paid leave program benefit just by virtue of being a state employee. But for others, such as private employers or non-state public employers, they will be allowed to opt in. And there's basically two ways to do that. So it's not mandatory, unlike other states who are imposing mandatory paid family leave. And we'll talk about Massachusetts in a bit. And many other states are following that, similar models. New Hampshire is kind of a model of its own at this point, and participation is voluntary. So for private employers with more than 50 employees, they will be allowed to contract directly with whatever the insurer chosen by the state. And those private employers will pay the premiums through payroll deductions from their employees, or the employer can choose at its discretion to pay a discretionary amount of those premiums, all or some, and will be given a tax credit of up to 50% for the premiums that the employer pays. So there is some incentive for private employers with more than 50 employees to jump into this, and they do get a tax credit for doing so. But for those employers who are either too small or they don't want to join, if their employees if their employees want to participate, they will be allowed to join in as well. And that will, there's going to be some logistics worked out on this as well. But what we do know is that they can't just jump in and immediately start taking these benefits. There will be a 7-month waiting period and a 1-week elimination period. And for them, there will be a premium that can't be more than $5 a week. So they're going to be allowed to purchase coverage through the purchasing pool, but there will be some contingencies related to that. So if somebody is employed by an employer, either a state employee or a private employer with more than 50 employees, or an individual who opts into this voluntary paid leave program, what will they be able to take leave for? And these are the types of reasons that we're all familiar with. If we know anything about FMLA, if we're large enough to have the federal family medical leave, or if you have offices or operations in other states, these reasons begin to look very familiar. So leave will be available to bond with a new child, either through a birth, adoption, or foster placement during the first year of either the child's life or during that adoption or foster placement. Also available to care for a spouse, a child, a parent with a serious health condition. And also then 2 military types of leave, including qualifying military exigency. So if somebody is going to be deployed, but they need to set up their will, or they need some type of leave for counseling, those types of exigencies will be able to be taken under this type of leave, as well as caring for a service member with a serious injury or illness. So the benefits are available not until 2023. So this program is supposed to be in place by January 1, 2023, with benefits available later that year. And as I noted earlier, the state of New Hampshire, this is through an insurance policy. So it will be administered by a commercial insurance company. There's going to be a selection process that will start in March of 2022. So there'll be some more information put out about who that insurer or insurers will be. But once that's in place, and once employees are able to take this type of a leave, they'll get up to 6 weeks of leave at 60% pay. But that pay is for high earners going to be capped at the Social Security taxable income limit, which will be $147,000 for 2022. And there's no minimum increment. So somebody could take a couple of hours and that would be covered under this type of a plan. So the employers who do opt in, or who are part of this, have a couple of other things to be concerned about. It's not just the payment of premiums, that if they do that, the state will automatically do that, but employers with more than 50 employees have the ability to chip in for those premiums. But if they do that, if they do opt into this program, there are certain other protections that come along. So it's not only the paid leave time, but it's also protecting the employee's job while they're out, giving them the ability to come back to their same or equivalent job, and also healthcare continuation. And obviously, with any of these types of paid leave laws, the notion that employees cannot be discriminated against or retaliated against for needing this leave, for taking this leave, for asking for this leave, for returning from this leave. So as I said, there's a lot of details still to be worked out, because it is kind of a unique program, the way that this system is being developed. But we will, keep you informed as we learn more. Now let's go a little south of the border here to Massachusetts, and I'm going to spend the next a bulk of time talking about various Massachusetts plans. Massachusetts has, for several years, had an earned sick time law. And one of the questions that we get most often, or one of the, I think, traps that we see that people aren't paying attention to, is the fact that this is mandatory for all employees. So it's not just full-time employees, it's not just part-time employees. It's also seasonal, temporary, interns, other employees who are doing work for the employer where their primary place of work is in Massachusetts. So somebody might be working in Massachusetts, Maine, and New Hampshire. And if the primary place of work is in Massachusetts, then this law will cover them. And if they're just working 6 hours a week as an intern, this law will cover them as well. Now, what that means is they earn or accrue sick leave at a much slower pace than others if they're only working 6 hours a week, but they do have the ability to earn this time. So under the Massachusetts Earned Sick Time Law, employees will earn up to 40 hours a year. And this can be accomplished either through an accrual system where they get 1 hour of sick leave for every 30 hours worked, or they could be awarded a lump sum of up to 40 hours for full-time employees. And if that happens on a yearly basis, that they get the lump sum on January 1st or their anniversary year or some other chosen date, if they have that lump sum awarded to them, then the time that they do not use during a year is forfeited, because on December 31st, for example, they have time left. It goes away because on January 1st, they have a new lump sum. So there's no carryover. But if they do not receive this sick time in a lump sum, if they accrue it, then they do get to carry it over into the next year. But the guideline in Massachusetts is you can earn 40 hours, you can use 40 hours, you can carry over 40 hours, but you can only have 40 hours in your sick time bank at any one time. So for those interns who work 6 hours a week, for example, it's going to take them a lot longer to have any appreciable amount of time off. And the employer can limit the amount or when they take the sick time, meaning somebody has to have worked for 3 months in order to be able to take sick time. So in some cases, an intern or a temporary worker may accrue the time very slowly, but they may do that. And then they're never able to take it because they don't work for the employer long enough. But the employer, that doesn't mean the employer should ignore that accrual, or there should be record keeping about the accrual, even if somebody's not going to take it. So what can this be used for? In Massachusetts, the purposes are to take care of an employee's own illness or injury that's not work-related. Work-related would be covered by workers' comp. So a non-work related injury, or to have preventive care. So to, go get, have a doctor's appointment, just a routine well visit. The sick leave can also be used for family members' illness or injury, or for family members' preventive care. So taking the parent of a spouse to a podiatry appointment, a non-emergent preventive care, that could be used, covered as well. And one point I didn't mention here, it also can be used for domestic violence purposes, but domestic violence leave purposes. So let's just jump over then to now the Mass Paid Family Medical Leave Program. So this was, there was a significant buildup in Massachusetts. This was took effect in 2019. That's when the contributions started, but there were not benefits available until 2021. So there was a good ramp up period and a lot of information was put out. So hopefully many of you are familiar with a lot of what's been going on, but there are some updates for 2022 that I want to share with you. So just an overview, we'll talk about who's eligible for the Mass PFML, who pays for it, what are the benefits, and overlaps with other laws. So at this point, at the end of 2021, what should employers already have done? They should already have registered with Mass Tax Connect for this program. They should already have started payroll deductions reaching back into 2019. And they should be making quarterly filings, paying those deductions into the state trust fund that will pay out those benefits. And they should already have given notice to existing employees, and as they hire new employees, giving the written notice to those employees as well. So who is eligible? Very broadly, Massachusetts W-2 employees. I'm not going to spend a lot of time talking about the other categories because I think that's there are some complications with self-employed and contractors, but I do want to focus on the Massachusetts W-2 employees because I think that's where most of the workforce will be for this this audience. So Massachusetts W-2 employees, and who pays for it? How is this funded? It is through contributions by employees primarily, but also maybe by employers, depending on the employer size. Those contributions are based on a percentage of an employee's wages. And as I mentioned, the Social Security cap for 2022 is $147,000. So for high earners for 2022, only the first $147,000 of their wages will be subject to this percentage formula that determines what their calculations are, what they pay into for the contribution rates. So employees have this deduction taken, as well as employers, and we'll talk about the employer's side in a second. So the good news for the overall contribution rate is that for 2022, the overall contribution rate decreased from 0.75% of eligible wages to 0.68% of eligible wages. And what that means is if you look at an employee's wages, 0.75% will be for 2021 has been taken out and sent to the trust fund to pay for these benefits. That percentage is going down to 0.68%. And I will also mention that this is a change. It's going. This is subject to change every October. So it did change in a favorable way for everybody in October of 2021. It will be reviewed again in October 2022. And currently, there are new posters, workplace posters, and the notice to employees available for the 2022 contribution rates. So employers should be alert to looking for the updated poster, because a poster does need to be posted in your workplace, just like for the Massachusetts sick leave law. And there are available now on the Department of Family and Medical Leave website, the posters and notices that you should be using going forward. So the overall contribution rate is 0.68% of eligible wages. Who pays that and how is that broken down? So it is different depending on whether the employer has 25 employees or more, or fewer than 25 employees. So if you look at this 0.68% of an employee's eligible wages, where does this money come from and where does it go? The employee, the Mass PFML is broken up into two different types of leaves. There's a medical leave, a personal leave for medical reasons component, and there's a family leave component. And so you will see that it is expected that more people will take medical leave. And so there's a higher contribution payable to that part of the program than to the family leave program. So the employee will be responsible for making their payroll deductions go to the medical leave part of the program and the family leave part of the program in the percentages that are listed here. And then the employer chips in when you have a 25 or more employee workforce. The employer chips in the other 0.336% of the weight of that person's wages to the medical leave program. The employer does not need to contribute to the family leave part of the program. So if you have a number, this is of the 0.68, this is how it's broken up, and this is who pays, and this is where that money goes. Now, if you have an employer with fewer than 25 employees, it's the same 0.68% that should be contributed, but in fact, the effective rate is going to be lower than that. And by that, I mean, the employee's rate doesn't go up. You'll see for over 25 and under 25, the employee contributes the same amount, the 0.224 plus the 0.12. So for under 25 employees, an employee looking at their eligible wages has to contribute that amount, and that is paid through payroll deduction to the state. But because of the size of the employer and the potential burden on the employer, the state has determined that for under 25 employees, the employer is not required to contribute any amount to either the medical or the family leave programs. But the employer can voluntarily cover some of what the employee should pay if they want to provide a more generous benefit to the employee. So I know it's a lot of math really early in the morning. I just hope you have your caffeine, but this is a description of where that money comes from and where it goes. So now we have a pot of money. It had accrued from, I think, October 2019 through December of 2020. And then as of January 1st, 2021, employees were able to take certain types of leave, their own medical leave, their bonding leave, and military leave. As of July 1st, the remaining benefits were available. So for employees who wanted to care for a family member with a serious health condition. So that was not, it took a little bit more time, or the program was allowed a little bit more time to build up some funds for that section of the population, people who wanted to take family member leave. So potentially some more good news, although it may not be great news for employers. What does employee get paid when they're out? Because this is a job protection, but also an income or partial income replacement program. So somebody who is able to qualifies for this leave, takes this leave, they will be able to receive some portion of their wages while they're out. In 2021, the maximum an employee could receive if they were out on some form of leave was $850 a week. In 2022, because the state average weekly wage on which this benefit calculation is based increased, the maximum benefit on a weekly basis that an employee will receive is up to $1,084.31 a week. That's a pretty big jump, and it's good news for employees. It may be not such great news for employers, especially for smaller employers where having somebody out may be a challenge. If this is more enticing for somebody to be the person in their family that has to take family leave to take care of somebody else, and they're going to get paid for it, maybe there's just enough more here that would tip the scale in favor of them being the person that does that. So I've mentioned some types of leaves that people would be able to take. And there are several, and it's important to recognize which type of leave somebody is taking, because there are limits and then there is a cap. So an individual employee can take medical leave of up to 20 weeks in a benefit year for their own personal serious health condition. A benefit year is judged by looking at the 12 months prior to when they take the leave, but it's looking at the Sunday before they actually take the leave. So if they start their leave on a Wednesday, you go back to the Sunday and you look 12 months earlier to see how much leave they've taken. Importantly, because we're still in this period of time where not all of the benefits, some of the benefits just came into effect. When you're looking back 12 months, you can't count any leave that was taken prior to January 1st, 2021 for medical or bonding, and you can't count any family leave that was taken, maybe under an FMLA program, prior to July. So we're still in this kind of transition year where people can take leave, they'll get these benefits, but you can't subtract maybe all of the time they took in the prior 12 months at this point, because not all of the prior 12 months were covered by this program. So this is an area that gets tricky for folks. These are the types of questions that we're answering and are happy to answer for people that have questions. But if somebody has a medical reason to take a leave, they are able to take up to 20 weeks. If somebody has a child and is going to take bonding leave or adopts a child, there's bonding leave available of up to 12 weeks. Somebody who delivers a baby and then wants to take bonding leave would be able to combine both their medical leave portion and the bonding leave, but they would be capped at 26 weeks. So as opposed to 32, if they took the full 20 weeks and then took 12 weeks, that's not going to be allowed. They will be capped at 26 weeks, but you do add those two types of leave together. It may well be that somebody who goes out on a maternity leave, for example, has a note from their doctor that they're disabled, they have a serious health condition for the first 6 weeks, and then that person would be able to take 12 weeks of bonding on top of that. So they would have 18 weeks. Now, if somebody is going to be taking care of a family member with a serious health condition, they would also have 12 weeks. But again, if they took some time for their own personal health condition earlier in the year, they might not have the full 12 weeks available to take from family leave. And then, as I mentioned, under New Hampshire paid family leave program, we're seeing also, as under the FMLA as well, there are options to take paid family leave to take care of qualified exigencies for a family member who has been or is going to be deployed, or to be a caregiver for a service member who has a serious health injury. And that one is the longest, that's 26 weeks. And that aligns with the Family Medical Leave Act, the Federal Family Medical Leave Act, which also allows 26 weeks for those. So again, it's very important to work with your employees to figure out what type of leave they're taking, and to be very careful about tracking what type of leave they have taken previously. Sometimes employees take time off and they don't treat it as a leave of absence. But if they've taken leave, sick leave, or some other type of leave, and it turns out then they need this type of leave, you may be able to count that earlier time as well as what they're now certifying as a medical reason or a family reason. So again, the message here really is be very conscious of how many weeks people are taking and what the reason is for. So I'm going to talk briefly about the overlaps with other types of leave. I've mentioned a couple of times the federal FMLA, and employers who have more than 50 employees will be familiar with this. It's a federal program that allows workers of employers with 50 or more employees within 70 miles to take unpaid leave. So how does this compare to the Massachusetts PFML? First of all, PFML is not limited by the size of the company. As we've seen, there are different calculations for contributions, depending on whether the employer has more than 25 employees or fewer than 25 employees. But any size employer in Massachusetts is required to offer this program. So that is a difference from FMLA. It's also not limited. The PFML benefits and job protection is not limited by the length of employment. The limit is that the employee must have earned Massachusetts wages of at least $5,700 in 2022 in order to be eligible for this program. So as long as they have contributed enough under Massachusetts wage laws, they've accumulated enough under Massachusetts wages, they will be eligible for this program. And it doesn't matter if they have not worked for that employer for 12 months or for 1,250 hours a year, which is the FMLA threshold. So under the FMLA, you're able to say, okay, well, this employee has only worked for us for 10 months. They're not eligible for FMLA. Or they have only worked 900 hours during the prior 12 months. They're not eligible for FMLA. under the PFML, employees will be able to take this leave when joining a new employer if they have $5,700 of wages accumulated in Massachusetts. Another important distinction is that the FMLA is unpaid. It's job protected, and it has substantial, 12 weeks, in most cases, 26 weeks for military caregiver leave, but it is unpaid. PFML is paid leave, as we've seen, and those numbers up to a little over $1,000 a week can be significant in allowing people to take that time off. PFML can be longer than FMLA. FMLA is generally 12 weeks, except for the 26-week leave for military or service member leave. PFML can be longer, as we've seen. So it can be for somebody's own personal medical condition, it can be up to 20 weeks. And if they have a personal medical condition and then they take time off to care for a family member, it can be capped at 26 weeks. So that's a significant change. Another unique feature of the Massachusetts PFML program is that it does cover former employees. So if somebody has been employed within the past 6 months and they now need to take a leave, they can apply as a former employee. It also covers more family members, so than does the FMLA. One part of this that is also unique is that under the FMLA, the federal program, employers can, if they choose to, require employees to take their paid time, their accrued vacation or sick, during an FMLA leave. And that's because employers who give this unpaid leave time then don't want somebody to be able to come back and take another 4 weeks of paid leave. So the employer in an FMLA situation could require the employee to take that paid leave at the same time that their FMLA is running. Under Massachusetts PFML, you can't force that. As a matter of practice, you cannot force employees to do that. Another question that comes up with regard to PTO is that under the Massachusetts Paid Family Medical Leave Program, employees are only receiving partial wage replacement. When I say the leave is up to $1,000 a week, that's just a percentage for higher wage earners. The percentage is not that high for most people, and this is not a full income replacement program. It's a partial wage replacement program. So there will be a gap between what the person's benefits are and what their normal take-home pay is. And under the Mass PFML program, you cannot allow employees to top off their time. If employees want to take their accrued sick leave to get full pay, or vacation time or personal leave to get their full pay, they can do that, but they won't get benefits from the Mass PFML program. They'll get full pay. They won't get the benefits from the state, but you can count that time against their allotment, and the department, you'll still have to treat them as on-job protected leave. So just think of it as they either get one or the other, and they can't add them together. But they're not, if they do decide I want to take sick leave so that I get full pay for this period of time, I have a ton of sick leave accrued, you can still treat that as working with the Department of Family Medical Leave. You can treat that time that they take as ticking away the days that they would be otherwise eligible under this program. So overlap with other leaves. This is the Mass program runs concurrently with FMLA. So somebody can't say, I'm going to take my unpaid FMLA leave and then I'm going to submit an application for paid leave through the Mass PFML. It also runs concurrently with Massachusetts parental leave law. So that law applies only to, in Massachusetts, applies to workers who are full-time or have been full-time for 3 months. And it gives them 8 weeks of unpaid leave per child. So if they have twins, they could have 16 weeks of unpaid leave. Or if they just have adopt or have a child, give birth to a child, then, or they're, they are the parent of a newborn child, they will be able to take that 8 weeks. So mass parental leave is available both to all employees, male, female employees, but it's also, it's only for full-time employees. So for those employees who are full-time and adopt a child, they can take their mass parental leave, but it would run concurrently with their mass PFML. So mass parental leave is unpaid, mass PFML is paid, and they can take that leave, and it will tick, basically count against both allotments. So Massachusetts, how does this happen, right? How do people take this leave? Massachusetts has set up what's called the Department of Family Medical Leave, DFML, and that is the entity that administers this program for many employers. And I'll get to the exception in a minute. If somebody is planning on taking a leave that would count against their paid family medical leave benefits, so they want that job protection and they want the benefits, they have to give notice to their employer first. And they will have to tell the Department of Family Medical Leave, DFML, they will have to say, that they've already notified their employer. And so that makes sure that the employer and the employee and the department are all on the same page about how much time is left to take, what other benefits the employee might be receiving, and what is the timing of the leave. So there is notice to the employer required first, and then an application process through DFML. Now, I mentioned there's an exception. Employers may choose to obtain a private plan. They may choose to set that up instead of participating in the state program. And that's allowed as long as the private plan offers the same or greater benefits as the mass PFML does, including not just wage replacement, but including some of the other protections job protection and reinstatement and that sort of thing. So many employers have done that. I have actually sort of recently realized yet another reason why that might be good for folks. I am aware that the Department of Family Medical Leave has, in some cases, allowed a fairly lengthy disability period, so under the medical program for employees who have delivered a child. And where short-term disability programs might say, the disability period is 6 or 8 weeks, the DFML might be saying that it's slightly longer, which means that somebody would have a longer medical period approved and then be able to take their 12-week bonding leave. And so it may turn out to be slightly longer under the DFML program than under a private carrier program. So that's something that, again, we're still, this is still the first year of the program. We're figuring all this out, and the DFML is figuring it out as well. So there will be certification forms if somebody does apply. And again, that's a way for the employer and the employee and the health professional and the DFML to be on the same page. But it's important to recognize that the DFML is the one that determines whether to approve or deny the leave. That's not up to the employer. If the employer feels there is some shenanigans happening, some fraud, some abuse of time, that's certainly something that the employer can bring to the department's attention. And I just want to spend, a brief minute on the coordination of benefits. It will be important to report to DFML what other benefits an employee might receive. I've talked about the fact that some people, they won't receive their full pay, might want to add a vacation and sick time, and that's not allowed. But the department has a pretty good set, it's not an FAQ, it's in their notice. They provide a pretty good explanation for employers about what happens if somebody is receiving other types of benefits at the same time that they're collecting benefits from this state program. I mentioned the notice that employers have to give employees, new hires and existing employees. And I would recommend that if you are beginning to become familiar with this program or need a refresher, if you have somebody taking this leave for the first time, that you look at those notices, because they're not your typical poster that you stick up on the wall. There's a pretty lengthy explanation that you have to give to your employees, and they have to sign off that they've received it. But one of the categories that's discussed in that notice is the idea that there are some benefits that employees can receive at the same time, and it won't affect their benefits, but they can't go over 100% of their pay. And there are other types of benefits that or other type of payments, for example, workers' comp or unemployment, or some extended illness leave bank. Those types of benefits, if an employee is receiving them, they would reduce the state payment dollar for dollar. So it's important, again, to understand what types of other benefits or payments this employee might be receiving, and whether that's going to impact the state payment that they received, and whether there's a possibility that they might be collecting more than 100% of their normal pay. So that's something to keep an eye on. So I've talked a little bit about it's not just a wage replacement, income replacement program, it's also a job protection program. And there's a couple of points that I wanted to make on that. First of all, that again, with this being a job protection program, it allows people to go out on leave, some of them for extended periods of time, and then be able to return to the same or equivalent position with the same benefits, status, pay, seniority, job, seniority credit. All of those types of things must be the same when they return, except if there was some job action that happened that would have affected them otherwise if they'd been there and affected similar employees. So if there's during COVID, there were people who were furloughed, there were people who were laid off. That could have happened to these folks taking leave as well. So, you need to look at what would have happened had the person been employed. However, if somebody who takes PFML leave comes back or wants to come back and their job is no longer available because of some legitimate job action that the employer took, that employee has to be given preference in hiring if their position comes back, or if an open equivalent position comes back. So again, this is an important thing for employers to be tracking, because you can't just say, okay, they're gone now. You need to be remembering, when we reopen that position, we rehire for that position, this person does get preferential consideration. Another aspect that I didn't mention on this slide, but is important, is the continuation of healthcare. And people should be returned to their same position when they come back. But people who are taking mass PFML leave also, as long as they continue to contribute the employee share to their healthcare, have to be maintained on the employer's health plan as well. And one of the biggest differences between the mass PFML and other, the federal program, the federal FMLA, for example, is a very clear anti-retaliation provision. Now, FMLA, the federal program, has both a provision that you cannot interfere with somebody's FMLA leave. You can't prevent them from taking an FMLA. You can't discriminate against them for taking an FMLA, and you cannot retaliate against them for taking FMLA. But the Mass PFML program adds some nuance to that that can be very eye-opening for employers. The anti-retaliation provision in the regulations for Mass PFML says that any negative change in seniority, status, employment benefits, pay, or other terms and conditions of employment, any negative change in those things during the leave or within 6 months after the leave, it's presumed to be retaliatory. The way that the employer can rebut that presumption is to show by clear and convincing evidence that the employer had sufficient independent justification to take that action. So if somebody comes back from a leave and is not performing well, is not showing up to work, is showing up late, not meeting deadlines, has an attitude problem, is really causing harm in the workplace. If the employer wants to take some sort of employment action against that employee, that employer has to be very careful to document. Make sure that you have the evidence you need before you terminate that person, or you change their status or reduce their pay, because otherwise it will be presumed to be retaliatory. So I see, let me see. We have some time. I think before we get too far afield from this, I see a number of questions. Let me just go look quickly with some of the questions that I've received. So one is for the New Hampshire leave. Is it 50 employees in New Hampshire or 50 employees overall? And that is including employees in other states. Actually, that's a question that I don't think has been answered, and I have seen that raised as a question. I think it's the Department of Administrative Services is the department in New Hampshire that will be responsible for fleshing some of that out. And I have not seen an answer to that. Maybe others have, but I do not have the answer to that question. And I think for the New Hampshire leave components, what we're seeing, we have the basics, we have a framework, but we don't have a lot of these details. So, a question about all employees being eligible, I haven't seen that there would be an exclusion for part-time workers. It may, that may be, again, something that is, if somebody is not already benefit eligible, it may be there'll be some exclusion for that, but I have not seen at this point the details for that sort of thing. Okay, so Mass PFML is the 25 employee threshold based only on Mass employees or all employees in the company. This is one of those areas you've got to go dig back in the regulations. I believe it is 25 employees in Mass. And if that is different, I will correct myself somehow later, maybe when we send out the slide to folks. But that is my understanding, is you're looking at Massachusetts. So one question is, if an employee combines the medical leave and bonding leave, which extends beyond 12 weeks FMLA, is that entire amount of leave job protected leave? And so this is relating to the Massachusetts PFML. If an employee combines those two leaves and it is beyond FMLA, the entire amount would be job protected under the Massachusetts PFML. So they would run those two leaves concurrently, Mass PFML and FMLA. They would run them concurrently, and FMLA would expire after 12 weeks, but the employee would still be entitled to job protected leave under the Massachusetts program, assuming that they're qualified. So another question is, how does Mass PFML interact or intersect with short-term disability benefits? And that is what I was referring to earlier. There's a pretty good explanation in the notice as well in the regulations, but in the notice that employers should download and make sure that their employees have seen and signed off on. I will say I am not sure whether a new notice will need to be given for 2022 with the new rates and everything. That's just sort of coming out now, the poster and the notices. And it may just be that the poster is enough. But that notice does say that a type of leave that will not reduce the state benefit is short-term disability. So the employee would get their short-term disability, their mass PFML benefit, and then they would get short-term, but they can't collect more than 100%. So the short-term, what's most likely happening is the short-term disability insurer is not paying the full amount if the employee is receiving mass PFML. And it may be, and again, that's another reason why I think some employers are using private plans, so that it can all be coordinated. But it is important to talk to the carrier for STD and find out how they're handling that. But according to the notice, forms of benefits that will not reduce the benefits that received from the department are temporary disability policies or programs, including both short-term disability and long-term disability. Another question is, with mass PFML, if you're a New Hampshire employer and the employee lives in Mass, are you required to pay this? If the employee works in Mass but primarily works in New Hampshire, does this apply? And so if you're a New Hampshire employer and the employee works in New Hampshire but lives in Massachusetts, then they're not earning wages in Massachusetts. And so this would not apply. So where your employee lives for this doesn't matter. It matters where they work. If an employee primarily works in New Hampshire but does have Massachusetts wages, there will be some, they should be, and their unemployment, this is all tied to the unemployment as well. So if they're paying into unemployment, they're also supposed to be paying into PFML. So there may be some allocation that it happens at that point as well, if somebody is part-time in Massachusetts. But if they're just living in Massachusetts and they're not a Massachusetts W-2 employee because they're working solely in New Hampshire, you're not going to have to worry about this. So my friend Amy asks, if someone has exhausted PFML for other reasons, do they still have the 8 weeks of unpaid parental leave? So if someone has exhausted PFML, they would have the 8 weeks of unpaid. Well, it depends. If they have exhausted it for this reason, then you would run it concurrently. But if the PFML was taken to care for a family member or a service member, they would have the unpaid parental leave available to them. And I want to be conscious of our time, but if an employee lives in Mass and works for a New Hampshire-based company but works remotely 3 days a week, does this mass leave need to be applied? Okay, so there's the big question between New Hampshire and Massachusetts. There's been a big dispute about when do remote workers have to start paying taxes in New Hampshire, in Massachusetts. What you will need to do is to just be very clear about, is this a Massachusetts W-2 employee? Are they earning wages? Is the test under unemployment is where the service is localized. So it very well may be that if people are working remotely, their services may be localized in Massachusetts and they may become Massachusetts W-2 employee who would be required to pay into this and benefit from it. So those are the types of, important analyses that you need to be making is, where is this employee working? How does this tie into unemployment and also to this PFML program? So, and are we going to slide this to the slide deck? Yes. Okay. So I'm going to jump on. We have some other topics to cover, but I think I've covered a number of those questions. And again, I will look into the 25 employees in Massachusetts, or is it statewide? Just this morning, that answer is just not coming to me as quickly as I would like. So Massachusetts COVID sick leave. There is another type of sick leave, COVID related, that has been approved in Massachusetts. And it's been in effect since May 28th of 2021. And it will last until April 1, 2022, unless the $75 million in program funds is exhausted. And I would say many of my employer clients are not taking advantage of this, are not using this. And it's that could be a reason why this program was recently extended. I think it was supposed to expire in September. It was extended till April 1. So how does an employee or employer access this? Under this legislation in Massachusetts, employers must give 40 hours of paid leave to employees for a variety of reasons. Now, that's 40 hours is presumed to be a full-time employee. The law and the publicity, or the whatever the announcements that the state of Massachusetts has on its website do give some examples of how to calculate the number of hours if they work part-time, or they work a varied schedule, or if they've been out and they haven't worked in the past 6 months. You need to look at averages. So if you have employees who are out for any of these COVID reasons, and they have, and you want to take advantage of this program, I would look at the mass.gov website under the COVID sick leave section, and it helps walk you through how many hours this particular employee would actually get. And so if somebody's working 20 hours a week and that's unchanged, they would get 20 hours a week, 20 hours of this time. And the reasons are not just for their own personal COVID illnesses, but also to care for family members. So this sounds familiar for those of you who are familiar with the Families First Coronavirus Response Act. Some of these reasons that people were taking leave are very similar to that. So if somebody needs to take time off to self-isolate for COVID-19, or if they're experiencing symptoms and they need to seek a medical diagnosis or treatment, they can take this time off. And they can also take it if they're told to quarantine, if they're required to quarantine by a governmental entity, if they are receiving or recovering from the COVID-19 vaccine, if they're caring for a family member for any of those reasons. So this is pretty broad, and I just think hasn't received the attention that it might warrant. Employers apply for reimbursement for giving this paid leave through Mass Tax Connect, which is the same resource that employers have to be registered for a Mass PFML and unemployment. The maximum to be paid and reimbursed per employee is $850. So that may not cover the 40 hours, but that's the maximum that they could get. What's interesting is that this says that the law says that employers cannot require employees to use other types of leave first. And I think that a lot of employers probably have said, well, you have sick time, you have to use it. And this program could be available to allow employees to use the state leave as opposed to their own personal leave. As under the earned sick time law, the Massachusetts earned sick time law, if somebody takes sick leave in Massachusetts, the employer can't require them to find a replacement worker. There is on the website, and I've provided an email address as well about this, but there is on the mass.gov website a pretty lengthy description of what information is going to be needed for employers to seek reimbursement. So first, it's the information that they should collect from the employee about the name of the employee, the reason that they're taking the leave, or the reason, and it could be family member for whom they're taking the leave, and a statement, which I think is important to avoid abuse, a statement that the employee has to certify that they are unable to work or telework. during this period of time. And then there'll be some additional information that the employer already has about the employee's social security number or other identifying information in order to be able to submit that information to the state for reimbursement. Now I'm going to talk briefly about two OSHA guidances, ETS, that came out in the past several months. The first one relates just to the healthcare employers. And it's an emergency temporary standard that was put out by OSHA in June of 2021. And the reason I bring this up is because we were referring to this quite a lot with our healthcare employers, but also when we were anticipating what OSHA might do for large employers, we were looking back and saying, okay, well, they've already allowed paid leave in some circumstances. And so we had a feeling that that was coming. So the OSHA healthcare ETS says that in order to address the grave dangers of COVID-19 in healthcare workplaces, there were certain things that needed to be done. At that time, in June of 2021, OSHA was encouraging vaccination and was telling employers to encourage vaccination. It was not a mandatory vaccine and still is not in under this ETS. But under this ETS, one of the things that was being encouraged is to provide, they were encouraging employers to recommend vaccine and to push vaccine, a vaccine program. But they were incentivizing that by saying that employers must provide reasonable time and paid leave to each employee for vaccination and any side effects that may be experienced following vaccination. So this was an incentive to employees to get vaccinated. They would be covered for both their time and paid leave if they suffered any side effects. So what does this mean? What is the reasonable time and paid leave? Under the healthcare ETS, which is in effect, employers who are covered by these ETS, which is mostly healthcare workplaces, have to pay time spent during work hours related to the vaccination appointment, which includes registering, completing required paperwork, and getting the vaccine. All time spent at the vaccination site, which for some people there was, post monitoring of 10 minutes up to 30 minutes or more, depending on their medical condition. So all of that would be covered as reasonable time that would be paid, as well as time spent traveling to and from the vaccination site, which many employers in the healthcare space were able to offer vaccination on site, but some did not. And so if people had to travel to a local pharmacy, all that would be covered. So that's the time to receive the vaccine. Let me just see here. Did I skip over here? Whoop, sorry. I'm sorry. So we have, there's also the time off to not only to receive the vaccine, but to recover. And that paid leave, how does this get paid for? The paid leave may be paid sick leave or administrative leave, according to the ETS. If it is available, the employer can tap into the accrued sick leave, or it would be additional paid leave. But the employer, if it's additional paid leave, the employers can cap the amount of time and paid leave to receive each dose of the vaccine and to recover. So the employer might be required to give reasonable time off, and the employee might not have it. And so what does that mean for additional paid leave? Under the OSHA ETS, they were saying that it would be 4 hours of paid leave for each dose of vaccine. That would be presumed to be reasonable. But if the employee chose to be vaccinated outside of the workplace, the paid leave would not be available to them, but they would still be able to take their time off if they had for side effects. So I just want to jump briefly now, and I know we have some time, but I want to give time for a little bit of more questions if there's any on this. The employer, the large employer ETS, which was issued on November 4th. It was long awaited, September 9th, President Biden said we're putting in a 6-prong path towards a path out of the pandemic. One of those prongs is to get as many people vaccinated as we possibly can, and large employers are going to be required to mandate vaccination. And OSHA was the agency that was charged with putting together an emergency temporary standard that would address a grave danger in the workplace of COVID, and to put out what the rules would be on the large employer mandatory vaccine requirements. So as we all know, that came out on November 4th, but it was stayed by a federal court on November 6th. And that stay was affirmed I think on November 12th. So currently we have a situation where we know what the rules might be, and we're uncertain when or whether they're going to take effect, because the ETS required vaccination for employers with 100 or more employees to be accomplished by January 4th. And so that's very likely going to be pushed. But one of the things that is important in this context is that if it does take effect, it will require employers to provide employees with reasonable time off. And just like under the healthcare, they get time off to receive the vaccine, and that can be up to 4 hours of paid time for each dose, as under the healthcare ETS. And in this case, you cannot deduct from accrued sick or vacation leave. If somebody, though, needs more than 4 hours to receive the vaccine for whatever reason, the excess above the 4 hours can be paid through their PTO. So this is paid time that the employer is providing. And if you'll recall, we used to have, for a period of time, there was the FFCRA, which allowed employers to give time off for the purpose of getting a vaccine. And that time could then be recouped through a tax deduction through the federal government. We do not have a recoupment mechanism here. So this is an additional 4 hours of paid time for each dose. And again, this is tentative at this point because the large employer ETS has been stayed. But if it does take effect, the other type of paid leave is to recover from the side effects after each dose. And that can be deducted from sick leave, and it can be capped at 2 days of paid leave. So if or when this takes effect, employers will want to be, again, tracking who's leaving to get the vaccine, how long is it taking them, what additional time do we need to pay for that? And then if they're recovering from the side effects, do they have sick leave? If they don't have sick leave, we have to give them sick leave, or an additional paid leave, but it can be capped at 2 days. So we want to be very careful to track all that. So again, as I mentioned at the beginning, the New Hampshire paid family leave program and this large employer ETS are the ones where there's most uncertainty. This particular standard is one that is potentially going to make its way all the way to the Supreme Court. So we're going to, keep an eye out on that, definitely. So I will open it up to a couple of questions. I'm not sure, but Jim Reedy may have joined, so I do want to leave him some time to mention some of the next programs. But I wanted to share with you all the most important slide of all for credits. So I'll leave that up and look and see if there are a couple of questions I can answer before turning it back potentially to Jim or Kelly, and otherwise letting you go a little early this morning. And we have a good comment. about the interplay between short-term disability and the Mass PFML. And as I had mentioned, STD insurers are going to reduce their benefits by the amount that the employee gets from Mass PFML. But also the comment is that if the employee doesn't take the Mass PFML benefit, the STD will still deduct the calculated amount from the STD payment. So I don't get into a lot of those areas of minutia. That's very helpful. I don't know if everybody's experienced that, but I thought it would be good to pass that along. One question is, do we have to offer additional time for vaccinations, or is paid time off, earned time off that employees have sufficient? And I think, I mean, that's going to depend on which program you're looking at. So if you're in Massachusetts, one of the reasons that somebody can take this mass COVID time is for a vaccine. So the employer might be able to, I would contact there's contact information for the mass COVID sick leave, and just confirm what the requirements are if it's, a 2-hour block for somebody to get the vaccine. So there may be time available, paid time, that the employer can get reimbursed for that. If it's a healthcare situation, the healthcare ETS provides for paid leave. And you'll need to look and see whether that can be tapped against paid time, as well as if and when the large employer ETS takes effect, there is paid time off for vaccinations, and that cannot be deducted. The time for getting the vaccine cannot be deducted for sick time, but the time that is used to recover can be. So I think checklists and flowcharts are and paying really close attention to a lot of the really great guidance that these agencies are putting out. What we learned from the FFCRA process with all the FAQs that were out there is that they really did try to address all of the questions and the scenarios that employers were facing. So I would look and see whether somebody else has had these questions, but I would definitely look at what the publications of the FAQs, the summary sheets, and I think I've answered that question, but I would say to look at those FAQs and summaries if you find you have a specific nuance that hasn't been addressed, because often you'll find you were not the first one to experience it. And I think I'm seeing a lot of repeated questions here. So what I'm going to do, it's 9:15. I want to and Jim Reedy is on. Jim, I don't know if you're there and if you wanted to give a couple of minutes of the next programs, but we've been going since just about 8, so I will pass it over to you.
And can you hear me?
Yes.
All right, great. Thanks so much. A couple of things. Terrific program. Thank you, Karen, for covering just this, I think incredibly complicated, but Karen was able to sort of put this together in a digestible format. There's no question that this can get very complicated with FMLA, paid family leave, and then also the differences between the states. So thank you, Karen, for doing that, and lots to learn, lots more to learn on this. And of course, when you thought all you had to deal with these days was COVID and COVID-related issues, there's, of course, the normal parts of, as we come into the high season for vacation time, holidays, and even people taking sick leave, an important topic for sure. So a couple of other things, and as Karen said, we've got the credits up on the screen, and that's for today's program. We've got other programs to talk about very quickly. So as early as tomorrow, we've got 2 programs, and Karen's one of them. Karen's talking about addressing another very important topic, substance abuse disorder in the workplace. And Karen can provide a bit more information on that. That is tomorrow. We've put that on LaborNet and otherwise, but Karen's got more detail on that. Tomorrow, we also have a MARA, Manchester Area Human Resources Association, Lunch and Learn from 12 to 1. That's been on LaborNet as well. And that's going to be on the topic of, as Karen just mentioned, the ETS program from OSHA and the latest and what covered employers should do, meaning large employers should do now while that Fifth Circuit decision is hanging out there and before the Supreme Court hopefully rules on this matter. And then on 11:30, on the 30th of November, from 10 to 11, Karen and I are speaking for, I think it's the Concord Chamber of Commerce, on this topic of hurry up and wait with regard to the OSHA mandate, the OSHA coverage of the vaccine mandate. And that's on the Concord, New Hampshire Chamber of Commerce website. And then finally, on December 15th, our annual event with regard to wage and hour. It's our annual review of the how to stay off the naughty list, and it's federal and state, New Hampshire, and to a certain extent, Massachusetts, wage and hour issues, top 10 wage and hour issues as sort of looking back and looking forward. That's Brian Bouchard is going to be presenting, and that is from 8 a.m. to 9:30 on the 15th of December. Karen, back to you very quickly with regard to the program tomorrow.
Yes, I'm going to be speaking tomorrow morning on a panel with hosted by the Recovery Centers of America. And it's going to feature the CMO, a chief medical officer, a practitioner at Recovery Centers of America, along with an HR professional and myself, and moderated by a person actually who is in recovery and has been for 3.5 years. And I just have to say, for any employers that are dealing with employees who may or are dealing with substance use disorders, this program, for me, I think it's going to be incredibly valuable because of the access to not only somebody who is in recovery, but an employer that knows how to deal with this. And the healthcare practitioner really is going to shed a lot of light that I think fills in a lot of gaps for employers who are not really certain of how to work through all this and what can they ask. Why does it take so long? Why does somebody need leave? What should we be expecting when they come back? So a lot of really great practical information that will address some of the legal issues, but I think there's going to be some good, the healthcare information and data that's going to come from this will be great. So we did post it on LaborNet. If it's not posted on the Sheehan Finney site, we'll get that up today. But it's from 9 to 10:30 tomorrow, and it's a free program through Recovery Centers of America.
I just want to mention one other quick thing, and that is statistics that come out with regard to COVID, in addition to all the other things with regard to whether it's isolation or the health effects of COVID. Statistics came out from several groups that show that during COVID, substance abuse skyrocketed, whether it's alcohol or drug abuse or both. And perhaps it's because of isolation, perhaps it's because of depression, anxiety, or pre-existing condition, but it is as significant as an epidemic as the pandemic is. And I think it's an important topic to address now, whether people are returning to the workplace or they're going to remain remote, critically important. And so thank you, Karen, and for your other panelists for putting this together. I think such an important topic. So thank you. And thanks again to Karen for taking the time to do this program today and putting this together. This program will be available for others to listen to on our website. Will be posted. And we just appreciate you taking the time. Thanks so much. And we look forward to seeing you in future programs. Thank you. Bye-bye.